Hello and welcome to the NAGDA Fiduciary Rule webinar. I'm Heather Baber from NAGDA headquarters. We're glad you joined us today. Before we get started with the presentation, we want to let you know about a few housekeeping items. First, please remain muted throughout the call so the presentation isn't interrupted. At the end of the presentation, there will be a question and answer period. Throughout the call, you may submit questions through your web console. Simply locate the question and answer panel on the right side of your screen, type your question in the open area, and click Send to submit. The PowerPoint presentation for today's webcast has been posted to the NAGDA website. If you would like a hard copy of the PowerPoint, you can access it on the NAGDA homepage at nagda.org. Just follow the link in the News and Events section located in the middle of the homepage. NAGDA couldn't offer the 2016 webinars without the financial support of our industry. Those sponsors include AXA, Empower, ICMARC, Lincoln Financial Group, MassMutual, Prudential, TIAA, VALIC, Voya, the Siegel Group, and Wellington Management. We are grateful for the support of these industry sponsors. Now on to the presentation. We have several individuals with us today for the Fiduciary Rule webinar. Joe Canary, Serena Simmons, Christina Cutlip, and John Shiner. Joe Canary is the Deputy Director of the Office of Regulations and Interpretations with the U.S. Department of Labor Employee Benefit Security Administration. Serena Simmons is the Senior Vice President at Siegel. She develops and manages the company's retirement plan compliance services and is the National Retirement Compliance Practice Leader. Christina Cutlip is a Senior Managing Director for the Institutional Retirement Division of TIAA and head of the Client Engagement and Advocacy team. Cutlip and her team are responsible for client engagement, relationships with industry and government association, national advocacy efforts. John Shiner has been involved in government affairs for more than 30 years. He began his career on Capitol Hill in 1969, working extensively on tax matters, healthcare financing, trade, Social Security, and income security issues. And let me just remind everyone that the intent of this webinar is to provide information, not legal advice. So at this time, I'm going to turn it over to John to begin our program.
I'm going to talk a little bit about the general background of the fiduciary rule and some of the developments in the political and judicial arena. The fiduciary rule began with the DOL publishing its final rule for the defined contribution plans on April 6th of this year. Well, insofar as state and local governments are concerned, DC plans are not bound by ERISA and DOE rules, but it can be expected that providers of investment services will likely treat participants in government plans similar to those in ERISA-covered plans. Furthermore, many NAGDA members already follow ERISA guidelines on a voluntary basis. So the statute as it is now exists and that authorizes the fiduciary rule essentially provides that state and local 457 plans are not subject to the fiduciary rule under ERISA, nor are they subject to the Internal Revenue Code section 4975, which also contains significant rules applying to pensions and deferred compensation and likewise. Now, this SEC has indicated it would issue fiduciary rules, but has not indicated a time frame. These rules would apply to state and local defined contribution plans because they would apply to all security sales and transactions. The recent election has led to considerable discussion over whether the new administration will implement the rule as scheduled or repeal it or modify it. There's no clear indication yet. However, some advisors that are transition have indicated opposition to the rule. Sort of odd and strange discussion of the rule. One advisor compared the rule to being as bad as the Dred Scott decision by mixing Supreme Court decisions and regulatory actions. I guess he was implying the fiduciary rule is enslaving brokers, dealers, and advisors. It's probably a little extreme, but there is some indications of reluctance on the part of the incoming administration. In any event, if the new administration wants to repeal or modify the rule, it will have to follow the process set forth in the Administrative Procedure Act. This may take several months to complete, just like it took several months to complete the implementation of the current rule to make it effective. It could also cease to defend the rule in the several cases brought against the Department of Labor to implement the rule. But in any event, some parts of the rule will survive regardless of DOL action unless there is a total statutory repeal, because in many cases the courts may still uphold the rule, and these cases will probably be involved in private cases where investors and brokers and dealers are dealing with each other outside of the Department of Labor's jurisdiction. Let me go over a little bit about what could happen also in Congress. The new Congress could also consider repealing or altering the rule. It could do so by defunding the implementation and appropriations bill. Congress will probably pass a appropriations bill for the fiscal year 2017 in March. It is possible that they could defund the implementation of the bill. Again, this wouldn't necessarily prevent the rule from being enforced on a private action, but it would probably mean the DOL could not take any action on the rule. It could also pass a bill to repeal or alter the DOL authority for the rule, which case, if it totally repealed the authority for the rule, then it's very likely that the courts could not enforce it in private actions. Most likely, the discussions about the Affordable Care Act and Congress would retain certain features while jettisoning others. So it's possible, like the Affordable Care Act, some things may be continued and some things may be dropped. So one of the things we're going to discuss here today, and I'm going to go over very briefly, and then my colleagues will get into more detail. When does the rule apply to transactions involving participants in government-sponsored 457 plans and other retirement savings plans run by government agencies? The rule clearly does not apply to advice when the funds remain in government-sponsored 457 plans. The law, ERISA, and Section 4975 Internal Revenue Code are very plain in exempting state and local governments from their application. The rule does apply to advice that involves the rolling over or transfer of funds from a government-sponsored plan to a tax-deferred plan, including IRAs and other 401ks. It is very likely the rule would not apply to advice when the funds are moved out of a government-sponsored plan to a non-covered investment, say an investment in a restaurant or another business or something of that nature. What has been happening lately on the fiduciary rule, even before the election, there have been several court cases challenging the rule. Preliminary injunctions have been denied in at least 3 federal district courts. The Federal District Court in the District of Columbia actually granted the Department of Labor summary judgment of a challenge. But in a hearing in the Federal District Court in Dallas, the judges expressed considerable skepticism about the legal basis for the rule. These court cases will continue and will probably take some time to resolve. The DOL did implement this rule, because it believes it will save employees money for their retirement funds, and it allow people to continue to benefit from significant retirement savings. The DOL contention is, in many cases, new retirees are advised to invest in expensive products that often yield those offering the products excessive compensation. Those opposed to the rules contend they will limit the availability of advice for many employees and retirees, because it will become financially impossible to provide advice and offer several products under the rules. The opponents contend that in order to assure evidence of acting as a proper fiduciary, organizations and individuals offering financial advice and products will be overwhelmed by the record keeping and the ever-present threat of legal action. So I'm going to turn it over to Serena Simmons, who will talk more about the details of the rule and what it means to the participants in your plans.
Thanks, John. Thank you, everybody, for listening and to the call this afternoon. As John said, I'm going to give you a quick overview of just sort of the basics of the rule. John's given you a very thorough background on kind of where it stands now and what the pros and cons and the controversies are. I'm going to talk about what it is, and what does it really do. And initially, I would say that the rule does 2 things. It expands the definition under ERISA of who is an investment fiduciary, particularly under the definition in ERISA, and I know these numbers are not something you deal with on a day-to-day basis, but there are 2 kinds of investment fiduciaries in ERISA. One is the type of fiduciary that's identified by
its function, what it's doing, is it functioning as a fiduciary, and the other is just a named fiduciary in the plan, or an investment advisor, or someone who is identified specifically as an investment fiduciary. This is the 321 functional definition, and it the statute says it covers anyone who gives investment advice for a fee. And the definition, the regulatory definition for that fiduciary is what has changed here. And as a result of the changes in the new regulation, those fiduciaries now, the individuals who were not fiduciaries under 321 as it exists today, but who will be fiduciaries come April of 2017 if the rule goes into effect, are going to have their lives significantly altered, their working lives significantly altered, because they will be fiduciaries. They'll have to give advice that meets a fiduciary best interest of the participant standard, and they can only receive reasonable compensation, which does not include compensation from other parties that where the advice they give affects the amount of their compensation. So that's one big impact, and the other big impact is that advice to individuals requesting a rollover from a plan will become covered advice and subject to the fiduciary standard. Under the existing rule, it wasn't covered, and so a whole new group of people and transactions will be covered with given fiduciary protection. On the next slide, we talk about the individuals who are affected, and we've already touched on that. The primary people who will be affected are those who are not acting as fiduciaries now, but who will be fiduciaries under the new rule. And as I say, there'll be a number of changes to how they have to run their businesses. And it's also the case that plans will be affected if they are covered by the rule or adopt rules that are similar to this rule, because but more in a standard fiduciary way. It's not going to change how they run their business. It's going to be a new set of fiduciaries to select and monitor, and some new monitoring obligations for some of the ways in which this rule can affect investment education and certain employees of the plan and the plan sponsor. The next slide is who's not affected. And who's not affected are investment advisors who are currently fiduciaries. They're already running under the fiduciary rule, so no change for them. Also, there is no changes intended for your other plan professionals, attorneys, accountants, and actuaries, to name the ones that begin with A. And the rules that are in place for them remain in place. Again, no intended change, but there's also no change in the rule that says if you act like a fiduciary, chances are you're going to be one. So any of these people, if they step out of their professional role and into an investment advisory role, specifically under these rules, would be a fiduciary under these rules. But that is up to them. John's already mentioned when the rule would take effect. It would take effect in April of 2018, unless, of course, it doesn't. Oh, I'm sorry, 2017, right. I'm looking right at it and saying the wrong number. 2017, only 4 months from now. So for those who think it's going to be go into effect without too much change, not much time is left to prepare. Under the current rules, however, certain parts of the rule will not go into effect until January 1, 2018. Those are parts of some of the exemptions that go with the rule that just plan sponsors and service providers and investment advisors needed more time to prepare for. And we're not going to, I should mention this briefly, the package of guidance that came out in April of this year really consisted of a number of types of advice. One was a set of regulations, and that's pretty much what I'll be talking about. The other parts of the package were new and revised prohibited transaction exemptions that are for the investment advisors themselves, that provide the new rules under these regulations for how those advisors, what they have to do and how they have to relate to the participants in order to continue to transact business the way they would like to. We're going to be talking about the plan consequences, not the prohibited transactions. So, on to the next page. Some may wonder why, the Department of Labor worked long and hard to get this rule passed. Why did they do that? Why did they think it was important enough to, go for 5 long years at least of trying to get this to happen? And I think you'll agree when you hear about it that it was an important thing that they did, and it was worth the fight. The rule that was in place, that is in place now for a few more months, is something called the 5-part test for the functional investment fiduciary. And as I mentioned, that rule just wasn't adequate for the current financial market. It went into the regulatory scheme in 1975, right after ERISA was passed, and things were a lot simpler then. IRAs had just been adopted into the Internal Revenue Code, so they were just beginning, and 401k plans were not yet approved at that time. And most people who had private sources of retirement income got that income from a defined benefit plan and didn't have any responsibility at all for its future investment. So in the world as it's developed today, the department believed that particularly participants in plans who were going to be able to take big hunks of money out and invest it for their retirement and have that be the only source of their retirement, that those people needed more protection. And that's really, in my mind, that's what made this worth all the trouble, protecting those plan participants. So what is the new definition of fiduciary? We have a 3-part test. It's gotten easier, at least in terms of the numbers of parts of the test. In order to be a fiduciary, an investment fiduciary under the new rule, you have to satisfy 3 requirements. The person has to make a recommendation for a fee about an investment activity. But the first thing is the recommendation. And the recommendation, it's not just chatting about an investment. It is, I think, often and very well described as a call to action. This is something you're intended to act on. The next thing is that the recommendation itself must be covered investment advice. And that's to say you're not just tossing something out, as an idea. It is advice to buy or sell a security, how to invest assets of some kind, including how to invest a rollover distribution, or how to manage your investment assets or investment property, or select an advisor, including specifically whether to take a distribution from a plan. So that is the kind of advice that has to be on the table. And then finally, the person giving the advice and the person receiving it have to be in what's called an advice relationship. And that is either the individual has already acknowledged his, her, or its status as a fiduciary, or it's pursuant to an agreement that indicates that the advice is being given on an individualized basis to the plan or the person, and it's directed to a specific plan or person and is specific about a specific investment. So if you're talking to someone on the Metro, it's not going to be investment advice. You're going to know that it's investment advice. It's in a serious relationship, and it's specific to the recipient. And all of that has to be satisfied, or it isn't investment advice. But if it is, what happens as a result of that is that the advice that's given, the person giving the advice is fiduciary, and the compensation has to be reasonable. There are a number of exceptions to this new rule. Some of them are, well, I guess they're all intended to cover what can be described as low risk exchanges. There's not likely to be a misunderstanding of what's going on in these exceptions. One is for general communications, and that's just like newsletters, brochures, anything that's just for general consumption. Another one that we'll probably talk about a little more and certainly might cover in Q's and A's is investment education. Investment education is also not covered. The new rule pretty much incorporates the old rule on the subject that you can provide plan information and you can provide general investment kinds of information, and it's not going to be considered advice unless you start getting specific with your recommendations. That's where you cross the line. A new exception under the investment education category is that plans will be allowed to continue to use or offer to their participants asset allocation models and other interactive tools, and those tools can actually reference plan available and specific plan available investments. But it's broader in a sense in that there are rules that the plan also has to talk about or acknowledge other investments in the plan and provide more information generally about the investment array. So it's not just straightforward. You can only talk about certain investments. Also, there's a specific fiduciary oversight responsibility that goes with those tools, and they have to be continually monitored and to ensure that they're following the requirements of the exception. So you need to be aware of that if that's something that you offer. Then there are some exceptions that apply to participant-directed plans specifically. On the slide that's showing now, these are the exceptions that would apply to a platform provider under the new rule. If your platform provider limits its interaction with you to the items identified on this slide, then that provider is not a fiduciary under the new rule. But as is the case generally, if that platform provider is giving you individualized advice on specific options to offer, that sort of thing, then the exception will not apply and your platform provider will be a fiduciary to the plan as well. And I'm not going to, in the interest of time, go through that, but I'll tell you more about the last group of exceptions, and those are primarily for sort of sophisticated transactions. Everybody involved in the transactions, with the exception of employee communications, the other transactions are designed to or identified because the people that are going to be involved on both sides sort of know what they're doing, and they're not likely to think that they're getting objective advice. They're getting sold something and they know it. The employee communications exception is something we're going to, I'm sure, be talking about more because it's of great interest to plan sponsors. And in general, if you have plan employees that are giving advice to a plan fiduciary about investments, they're accepted as long as they're not getting a separate fee for doing that. They're just getting their regular comp. And if you have employees who give advice to participants sort of in an HR capacity, they will fit the exemption if they're not otherwise investment advisors or registered or licensed advisors, and they're not receiving a fee. But these things can get tricky, so this will be an area that plan sponsors will want to pay attention to. And so, with that, quick run through the regulation, I'm now going to turn it back to Heather for a polling question.
Thank you. Our first polling question is, Do you plan to communicate anything to participants around the new fiduciary rule? Give everyone a few minutes to answer. Looks like no, one on that one. So at that, I want to toss it back over, or I'm going to toss it to Tim.
Thank you very much. This is not a normal stakeholder group for at least my element of the Department of Labor, so it's nice to be here. Most of the time when we're talking to government plan administrators, it's talking about not being covered by ERISA rather than what we're doing under ERISA. So number one. Number two, I know some of this information is very general, and you all may have follow-up where you'd like to talk to the department more on a more one-on-one basis, or sort of dig deeper into what you heard today. We're definitely open to having those kinds of communications. So if you don't have, as part of this session, contact information for us, we'll make it available to you so you know where to follow up if you want to have discussions about individual issues. I think my role other than that here today was to focus on really two issues of particular interest that I understand the government plan administrators have, and how the fiduciary rule, conflict of interest rule, applies to those areas. One is what's already been talked about a bit already, the rollover recommendations, number one, and two, sort of related to that is what about call center communications, both the administrator that is running the plan as a governmental official, having a call center function, or outsourcing that to a contractor or private sector TPA. So I'll get into that in just a second. Before getting there, I think Kathy did and John did a great overview, and just for purposes of setting up what I'm going to talk about, think really big picture about the way the rule is structured. Number one, it applies to ERISA plans and IRAs. So when you're thinking about internal communications that you're having with your participants, education to your own participants, dealing with investment providers regarding your own plan, those activities generally not impacted by the rule. That's sort of internal to the governmental plan operation. If, as John pointed out, you end up having parallel rules under either the plan or state law to ERISA, you might need to think about how this regulation then applies when you're applying your own laws or rules. But that would be really incorporating our concepts into your rules and trying to figure out how they work that way. Number one, so generally governmental plans, when you're dealing with your own people, this is not a rule that impacts you. Number two, the rule, you can think about it the following way. One, as Kathy pointed out, we've defined what an investment advice relationship is much more broadly. So more people are now going to be covered as investment advice fiduciaries. And Kathy went through and said there's a rule, you have to meet the rule. Number two, the rule also tried to provide some clarity to say not every communication you have about investments or with people who are financial institutions is investment advice. So we had specific exceptions. So you first say, is the communication covered by the rule? Is it not? Is it outside the rule because of these exceptions? That's the rule. So now let's assume I am a fiduciary, I've given investment advice. The consequence under ERISA, if you were dealing with a private sector plan, is I'm a fiduciary, I have to act prudently in the best interest of the plan, the participants and beneficiaries. I need to avoid prohibited transactions unless I'm relying upon an exemption. And one of those big prohibited transactions is self-dealing. So fiduciaries telling people in the plan to invest certain ways where that's going to get the fiduciary compensation or fees. That would be a self-dealing violation, which you couldn't do unless you had an exemption. If you were dealing with an IRA, so the prudence obligation doesn't attach directly, but the fiduciary in the IRA still has to avoid those prohibited transactions, the self-dealing. So you have to say, have I given advice in the rule? Am I receiving compensation that would be a prohibited transaction in the absence of an exemption? The answer is, yeah, I've got prohibited compensation coming this way. Then you need to look at the exemptions. Say, is there an exemption that covers so I can continue to get that compensation, and what are the conditions I have to meet? And there's a series of exemptions that were published at the same time of the rule that were designed to allow people to continue to receive sort of normal types of compensation that already exist in the investment marketplace, subject to conditions that were designed to protect against conflicts of interest and make sure fiduciaries were making best interest recommendations when they're talking to participants in plans or people with IRAs. So that general context. So in the case of rollovers, that's one place where you're not dealing internally with a governmental plan anymore. You're saying, so someone is coming to your participants, and the same thing happens in the private sector, as you all know, coming to the participants saying, you're near retirement age, or you're separating from employment, do you leave your money in the plan, what do you do with it, you roll it into an IRA. IRAs are covered by the rule. It doesn't matter where the money comes from. So the fact that the money's coming out of a governmental plan doesn't mean that communications or transactions involving that IRA are somehow not covered in the same way that the governmental plan would not be covered. So IRAs are covered. If advisors are making recommendations about rolling into an IRA and how to invest the money, that would be covered by the IRA provisions in the rule. There may be some sort of super technical kind of issues about whether I'm only talking about the rollover versus I'm talking about how to invest the money. But I think it's a practical matter, and you all, I think, probably have more experience than I do because you're dealing with the participants on a regular basis. Those communications tend to be mixed. If someone's coming to your participant and saying, let's think about rollovers and how to invest your money after you roll it out of the plan, that you're going to end up with a covered conversation, that the recommendation is going to be investment advice, and those advisors are generally going to get paid fees in connection with those advice. So you're going to end up in those conversations, people being fiduciaries, and there being prohibited transactions. So the rollover issue is an area where, and I think as I understand it, your interest is saying, so what do I tell the participant? So if you're being approached by an advisor, what can you expect? What are their obligations to you? And I think the way that would work is that the communications are generally going to be fiduciary under the rule. There's going to be a prohibited transaction in all likelihood. Someone's going to have to rely upon an exemption. The major exemption there that's going to be in play is the best interest contract exemption. And the best interest contract exemption has sort of some overarching conditions. I'm not going to get into the details because I think the other thing we may be able to do is work collaboratively with you or with the association if you're trying to put together sort of outreach materials that would cover some of this. But the exemption requires that the advisor meet impartial conduct standards, that they have in place anti-conflict of interest policies and procedures. There are certain disclosures that have to be made regarding the transaction, both at the individual level, and there have to be sort of more general information available on websites regarding conflicts of interest. That impartial conduct standard, oversimplified, requires that the advisor make sure that they're basically acting in accordance with what would be the ERISA prudence requirements. They have to be prudent, make recommendations in the best interest of the advisor and without regard to their own financial interest. They can't receive more than reasonable compensation, can't obviously make misleading statements, and there has to be an enforceable contract where they said, you know, we're under an obligation to you as the advisor to do all these things in this contract, and we're acknowledging our fiduciary status. So those conditions are out there, and people should say, if I'm getting an advisor, I'm getting this advice. Those are the sort of things that they should be looking for to say, yeah, this advisor is really supposed to be doing these things, and if they're not, there's going to be a problem. Now, as John and Kathy both pointed out, there's an applicability date and a transition period. So these rules are not applicable until April of next year, and from April until January of 2018, there is a special streamlined compliance environment, which would not involve having a contract, but some of the other conditions apply. So what I'm talking about is generally about what's going to happen in January of 2018. The transition provisions are a little bit more complicated, and as we can get into that, maybe the different circumstances, if that's of interest. So that's rollovers. And the call center issue is related. Because I think if you're, again, dealing with the call center and the call centers, we're getting normal calls from your people. They're saying, so I want to know something about the plan, or what are my distribution options, or can I get information about my account? All those sort of communications with the call center are not covered by the rule. Now, if the call center is getting questions about, okay, I'm getting ready to retire, or I have a separation, what sort of distribution options are available to me? What about rollovers? How do I do that? Do I have to fill out forms? What are the forms, et cetera? That's the point where if the conversations start to be a recommendation on rollover, that you sort of merge back into what we talked about rollover recommendations. I think in general, if you're running your own call center, those conversations don't end up generating a fee. So just like private sector employers, when they're talking to their employees, they don't get a fee or comp when their people are talking to their employees about their plan. If you're dealing with the private sector party, issue is not as clear, because that private sector party may actually have their own IRA providers, that may have their own investment options, and they may have an interest there in sort of connecting these people who are leaving the plan into their own products or their own services. So the private sector call center employee might then sort of make a recommendation to roll over, and that could be a covered investment recommendation. There may be fees or compensation that's received, maybe not by the call center employee directly, but by sort of the company or an affiliate in connection with the rollover, where you're again saying, well, so does that call center function need either make sure that the communications they're having are educational, and there's a lot of things they can tell people about rollovers that's still education, or does it cross over into recommendations? And if it's crossing over into recommendations, are they set up to be in compliance with the requirements that would apply for an exemption to be available if they were getting comp as a result of those recommendations? So the call center issue, if you're talking about private sector, is a little bit more complicated. It's going to depend on the facts and circumstances. And that's a place where you may want to follow up with us directly. We're dealing with a lot of stakeholders. A lot of people have questions. We're having ongoing meetings with people about how the rule of the exemption works in particular circumstances. Some of those meetings are happening at a company level, plan level. A lot of them are happening at association or trade group levels. We recently put out a set of frequently asked questions on the best interest contract. We're about to put out another set of frequently asked questions about the rule, and we're continuing to be sort of open for business in terms of receiving questions and trying to really be proactive in helping people understand the rule, how it applies to them, what it takes to be in compliance. And I think I will stop talking at that point and we can move on.
Thank you, Joe. This is Christina Cutlip, and a lot of what I was going to cover was actually covered very, very well by Joe, and also by John and by Serena as well. So I'll just run through some of what you have already heard, but with a slant from a provider's perspective, and from a provider who also has financial consultants as well as part of our team. So as you have heard, plan providers have been hard at work working to make sure that they can actually implement this rule. Regardless of what happens between now and then, most of the providers are operating as if this rule is going to take effect on April 10th. And if it doesn't, then we'll adjust accordingly. But everyone that I have been talking to in the industry who works with a lot of your plans is proceeding as if the rule is going to take effect and take effect on April 15th. There is a lot to be done administratively to make sure that to make sure that the companies do comply with these rules. Just from what you heard from Joe, there are some complexities, especially when it comes to fund centers, et cetera, that people are still working through. So again, I'm just going to recap really quickly. For non-ERISA plan sponsors, it's going to generally be business as usual because this rule, as John and Joe and Serena explained, it really does not apply to non-ERISA plans, but it definitely applies to ERISA plans, and it applies to IRAs as well as ERISA plans and ERISA plans. So, as a fiduciary providing advice to rollover distributions from a non-ERISA to an IRA or an ERISA plan, that's going to be covered under this rule, and so the big exemption is going to apply. So for plan providers, when they're working with participants, and if they are having a conversation about moving funds from the retirement plan, which most of your retirement plans, into an IRA or into an ERISA plan, because they could be moving from your plan into an ERISA plan, either a for-profit or a not-for-profit ERISA plan, this rule definitely applies. So when someone, for example, calls the fund center of many of your providers, and they're wanting to move money from your plan into another plan that provider might or might not cover, they need to understand your rules. They need to understand the rules and the plan that they're trying to move those funds to, or the IRA that they're trying to move those funds to, and be able to provide the appropriate advice based on that, on that knowledge. So the other thing that they also need to understand, even though they are working with your plan, is if they're going to be moving money from your plan into an IRA, which they may have, or if you even have an advisor who works with your plan who is who is trying to move money from, who is working with a participant trying to move money from your plan into an IRA, that advisor is now subject to these rules and needs to understand the rules of your plan. They need to understand how your plan is structured and the institutionally priced investment menu that you have, so that when they're providing the advice to that participant who is rolling over to an IRA or an ERISA plan, they can actually provide them with advice that is in their best interest and not in the interest of the advisor. So again, this is more to reiterate. It is important for you as a plan provider, for you as the plan sponsor, it is important for you to understand what your providers are going to be doing and how they are going to be engaging with your plan participants. Are they going to be, following the rules regardless? Are they going to be following the rules only if your plan participants are moving from your plan into an IRA or into an ERISA plan? I think those are some of the critical questions that you need to ask your plan provider. Are they going to treat all employees equally, or are they going to treat the non-covered employees differently? Also, some of the questions that you need to be able to get from your advisor is, are they using the best interest contract exemption? And that way you can understand how they are being compensated, as Joe mentioned earlier on this call. So again, to just kind of summarize some of what you heard, what's changing and what's not changing. I know you heard this from Joe, from John, and from Serena. the rollover, the transfers and distributions recommendations that are the primary targets of this rule and will now be covered under fiduciary advice. And I did mention that although your plans are specifically not covered, but if someone is having a conversation with your employees and wanting to move them out of the plan, that is now covered. Any professional providing financial investment advice will need to also know, they'll need to do so in the participant or the recipient's best interest, which means they have to understand the plan that the participant is in, as well as the investment in the plans that they are going to be moving into, so that they can actually give them advice that is in their best interest. What is not changing, and Serena did a very good overview of this, general education, that is not changing, that is going to remain pretty much as it's been. Asset allocation models, those are not changing. You can still provide those. Investment advice services from a provider acting as a fiduciary, that's really not changing. And then direct movement of assets where the provider acts as just an order taker, that is not changing as well. So if a participant calls a call center and says, I want to move my money from this plan to this plan, and they are basically saying, giving you the direction, that doesn't fall under the rules. So as a plan provider, what are some of the questions that you need to ask? And before we get into that, let me just throw it back to Heather. She has a polling question that she's going to ask.
Thanks, Christina. Yes. If you'll look at your screen, our next poll question is, a staff member has been making what I think might be specific investment recommendations under the new rules to some participants. Is she or he an investment fiduciary? Looks like the majority said yes.
Okay, that's an interesting, because the answer to that, if it is a staff member and they are just talking to a participant about the general provisions of the plan, they are not really a fiduciary under those circumstances. Okay. And I'm going to move on to the last slide so that we can leave time for a few questions here. Some of the questions that we do think you should be asking you should be talking to your participants about asking their advisors. We listed some questions there under, do you consider yourself a fiduciary? They should be asking the advisors, if you do, why do you consider yourself a fiduciary? And if you don't, why not? Also asking them if they are willing to ask as a fiduciary with the duty to act solely on their behalf. We think those are just good questions, and we think for participants to make good decisions about their retirement, they need to have someone who is acting in their best interests anyway. So we think those are some of the questions that plan participants should be asking. They should also be asking how are they being compensated? Are they earning fees or commissions? I think those are just basic questions, and some of the questions are right there on the slide. I won't go through each and every one of them. And last but not least, is the person that they are working for licensed or registered, or a registered investment advisor? And I think those are some of the questions that your plan participants should be asking. And you as a plan provider, you should also be helping your plan participants ask these questions. So it might be a good idea to have like a list of questions as part of your education program that you provide your plan participants, so that when it comes to a time when they are retiring or when they are terminating employment, or if they are making any other changes to their retirement plan, these are some of the questions that are just good for them to be asking the advisors, to make sure that that advisor is actually working in their best interest. And I'm going to stop there, because a lot of what I was going to cover has already been covered, and throw it back to you, Heather.
Great, thank you. Thank you, Joe, John, Serena, and Christina. We appreciate the information you've shared today and keeping our members up to date on the fiduciary rule. I'd like to remind you that you may submit questions through your web console. Simply locate the question and answer panel on the right side of your screen, Type your question in the open area and then click Send to submit. We will try to answer as many questions as time allows. Also, today's PowerPoint presentation is available on the NAGDA website at nagda.org if you'd like a copy. So let's see if we have any questions coming in. Someone is asking, will the webinar be available after today? Yes, it has been recorded. And that, again, will be on our website. You can check on the News and Events page and on where we have the webinar information today. You can also get the PowerPoint there. Any other questions?
As we are waiting for questions, I just wanted to also suggest that for members that are working with plan providers, you can feel free to reach out to your plan providers to ask for information and ask how they are preparing for this. I know most plan providers are more than happy to share with you. Most of them are launching their their information in January, but they should be able to at least share some preliminary information on how they are working towards complying with these rules and regulations.
All right. We do have a question. Can our call center provide advice on moving along investment options within our plan without becoming a fiduciary?
And I will start, and then Joe, you can probably chime in as well. If you have a fund center and the participant calls in and they're just wanting to move money within their retirement plan itself, that is totally okay. They can do that without the advisors, violating anything. So that is okay. So Joe, do you want to chime in on that?
Sure. I'd probably just say that a little differently, which is you're having a conversation internal to the governmental plan where you're just saying, my people want to know how to invest and what the investment options are inside the governmental plan. Those conversations are not covered by the rule. There may be other requirements that attach. You may have your own rules and guidelines for call centers. There may be other state or federal laws that would relate to that communication, but it would not be a communication that would be investment advice under the department's rule, because it's all internal to the governmental plan. You're not talking about taking a distribution, a transfer, a rollover, which is where the rule then tends to come up and touch the governmental plan.
Some might have been answered already, some of it. One question is, part of the agreement with our record keeper for our self-directed plan is that they would provide investment advice to our membership. They are not being paid directly by our members, but they do fall under this new rule. Question mark, do they?
Can you read that one more time?
Yeah, part of the agreement with our record keeper for our self-directed plan is that they would provide investment advice to our membership. They are not being paid directly by our members. Do they fall under this new rule?
I think that's the same answer, which is that's all internal to the governmental plan. They may very well be fiduciaries under state law, your rules. There may be securities laws issues that would attach to the relationship, but their status would not bring them within the scope of the department's rule, because it's all a conversation internal to the governmental plan.
Okay, another question here. If a plan sponsor has indications that a service provider has staff that may be providing advice to participants that could be covered by the fiduciary rules, i.e. other products offered by the service provider, Does the plan sponsor have any liability if the service provider does so without properly complying with the rules?
It's a fine legal question.
Well, so the questions that have any tend to be sort of any obligation tend to be hard because you're probably carrying a pretty broad scope, and I know there may be issues in terms of plan rules, state law, applicable regulations that have nothing to do with the Department of Labor rule, number one. Number two, let's put that in a context of sort of someone who's making a recommendation to roll over out of the plan. And let's assume that conversation is covered investment advice under the rule, and the person is receiving compensation, and they really need to be in compliance with the best interest contract exemption to receive that comp. I think that the primary obligation there is obviously on the advisor to make sure they're in compliance with the rule, and if they're not, they've got a prohibited transaction and legal exposure in connection with that prohibited transaction. If you were in an ERISA plan space, the plan fiduciaries might have what's called co-fiduciary responsibility, or just general fiduciary responsibility when they're hiring service providers to monitor the service providers and make sure that things are sort of going okay. How that would apply in like individual circumstances as opposed to more general obligation would depend on the facts and circumstances.
If I'm understanding that question, Joe, you might help me on this one. If the service provider is offering products that are not covered by ERISA because even outside, they're not IRA, they're not retirement, maybe it's just like an ordinary term life insurance policy that they're saying buy with your funds that are not part of your defined contribution plan. I can't imagine that ERISA would apply. Well, fiduciary rule would apply if it's like a complete other product, like say term life insurance or property and casualty insurance, something like that.
Right. Well, so the rule applies, as I think Serena said, to investment advice, and we do have a definition of what investment advice is and what would be securities or other sort of investment property. And there was specific discussion about term life insurance in the preamble, where we think generally term life insurance would not be an investment product, but the rule said that these insurance products, if they don't have an investment component, would not be covered by the rule. So I think we are getting some questions about people when they're retiring, receiving recommendations to have term life insurance somehow built into an investment structure, where that's a question we're getting, and that's like one of those individual one-off issues. But so generally I think you're right, but it depends on the circumstances.
And I think, like we mentioned before, just understanding how your service provider is engaging with your plan participants will go to answer that question. And also, if you're doing an RFP, I think having that as a question in your RFP is also critical for you to understand how your participants are doing.
And Christina, someone is asking if the questions that you provided today, that you reviewed, can they be provided to participants as suggestions to ask plan sponsors?
Absolutely. Absolutely.
And then will you all please clarify when the fiduciary switch is flipped?
Sure. So there's the rule, and then there's the exemptions. The rule says who's a fiduciary providing investment advice. That rule becomes applicable in April of 2017. I think it's April 10. At that point, people would have to say, well, am I a fiduciary under the rule or not? If they're a fiduciary under the rule, then they have to say, am I a fiduciary dealing with IRAs or plans? That's going to dictate whether they have sort of more general prudence obligations under ERISA if they were dealing with an employee benefit plan, versus they're only operating under the code as a fiduciary. where they have to make sure they avoid prohibited transactions. If they're a fiduciary, they're getting comp that would result in a prohibited transaction, then both the ERISA fiduciaries and the code fiduciaries have to comply with an exemption for them to be able to get that compensation without violating the law and engaging in a prohibited transaction. Primarily, that's the best interest contract exemption. There is a transition period from April 10 of next year where people would say, am I a fiduciary or not? Do I need to worry about prohibited transactions or not under this rule? Until December 31st of 2017, where you still have, if you have a prohibited transaction, you still have to have an exemption, but the best interest contract exemption and something called the principal transaction exemption have some transition rules where you don't have to comply with all of the conditions, but you have to comply with some. Beginning in January 1 of 2018, you're going to have to then be in full compliance with the conditions of the exemptions if you want to continue to receive compensation that would otherwise be a prohibited transaction. So I hope that's clarified.
Great, thank you all. Well, it's a little after 2. Sorry we ran a little long, but it's time to wrap up the webinar. We look forward to seeing your survey responses come in and encourage you to reach out with any questions. Thank you so much for participating, and many thanks to Joe, John, Serena, and Christina for sharing their time with us today. Have a great rest of the week.
Those